started.
Hello, everybody. Like Takao said, my name is Kelsey Beckner. I am a solo practitioner and immigration attorney, and I have my own law firm, Beckner Immigration Law. And I have been practicing immigration law almost exclusively since I graduated from law school in 2009. And my focus has been asylum. The point of this training is really to give you an introduction to immigration law, a really quick introduction to asylum law, to help you kind of think about what's going on with cases right now, some of the cases that you'll be seeing, cases that are in the detention center right now, so you can kind of issue spot and figure out the things that you'll have to do, the arguments you'll have to make for these cases. So I'm going to start with the basis of immigration law. It is a statute, the Immigration and Nationality Act, also known as the INA. And when we talk about comprehensive immigration reform, we really talk about overhauling the INA because it's a pretty old statute by this point and really doesn't address a lot of the current problems we're having in our country with immigration. We also look a lot to the regulations, in particular Title 8 of the Code of Federal Regulations for our law on immigration, and then we look at the cases that are interpreting that law. There are a few Supreme Court cases. Most of the law we look at, though, are the U.S. Court of Appeals cases here in the Ninth Circuit, and then the Board of Immigration Appeals cases. Some of the Board of Immigration Appeals cases are precedential, some are not. I like looking at the Ninth Circuit cases personally, but we also do look at the Board of Immigration Appeals. And the immigration courts are the trial level courts. They make decisions on particular cases, but they don't really set precedential decisions. So we can't really rely on those decisions for our cases. What agencies are in charge of immigration law? After September 11th, 2001, the events of that day, basically the government overhauled what was then INS and created the Department of Homeland Security. And so included in the Department of Homeland Security are 3 immigration agencies. Also FEMA is included in DHS and a couple other things. But for us, we think about USCIS, which is the part of the Department of Homeland Security that does affirmative benefits, green card applications, citizenship applications, initial asylum applications. So they're more what we call benefit givers of immigration law. And then we also have Customs and Border Patrol, CBP, who are the people who are at the border, who you see when you're at the airport, coming back into the country, when you're crossing the border from Canada. They're also given jurisdiction within 100 miles of the border, so we see them in Seattle because we're within 100 miles of the border. And they are really on the front lines down at our southern border right now. So we're hearing a lot more about CBP right now. And then we also have ICE, which is such a lovely acronym for such a lovely agency. But that's Immigration and Customs Enforcement, which are really kind of the police officers of immigration. They enforce removals from the United States. They arrest people. They raid companies. They do all kinds of things in line with enforcement of immigration laws. So other than the Department of Homeland Security, we have the U.S. Department of State, which oversees the embassies and consulates and do visa processing. And they also have a branch called the National Visa Center, which is here in the United States, which also processes, does kind of initial processing of visas here in the U.S. And then we have the U.S. Department of Justice, which oversees the Executive Office of Immigration Review, or EOR. And in that EOR is the immigration courts and the Board of Immigration Appeals. And that's why when Jeff Sessions says something about immigration law or how it should be, we all get very concerned, because basically he is the boss of immigration judges in our country. Okay, so what are the different types of immigrants? You know, sometimes people are like, well, why isn't this person a citizen already? Or, you know, when can they apply for citizenship? Well, there are different processes for becoming a citizen. The main way that someone becomes a citizen is they first become a lawful permanent resident. And lawful permanent residents, or LPRs, can reside here permanently. Most of them can apply for citizenship after 5 years. Some can apply after 3 years. But most people have to become an LPR before they become a citizen. And so really, the difficult thing is first becoming a lawful permanent resident. So that's a lot of the work I do, is helping people get to that first step. So then lawful permanent residents are people here who are supposed to reside permanently. On the other hand, we have non-immigrants, or people who are supposed to be here temporarily, like visitors, or people who are here on H-1B visas, or students. Those are people who are non-immigrants. They have not shown the intent to stay in the United States permanently. They're not allowed to stay in the United States permanently on their visa status. When you hear about overstays, like people who've overstayed their visa, that's because they came here on a temporary visa or a non-immigrant visa, and then they stayed here past the time when it expired. One other kind of large category of immigrants, which is less large now under Trump than it was under Obama, are refugees and asylees. Refugees, I just want to note, under the Immigration and Nationality Act, are different from asylees in the sense that refugees get their refugee status overseas. They apply for it overseas in a third country, and then they enter the United States as refugees. So they come here with that status, whereas asylees are usually here in the United States first on another type of status, like a student visa or a visitor visa, and then they apply for asylum once they're here. But basically, anybody who is here can apply for asylum in the United States. And then there are other categories I'm not talking about, but we also have a large population of undocumented immigrants in the United States who don't have any immigration status. They came here without a visa, and they're just kind of living with this lack of immigration status. And that's, you know, I have clients who've been here 20 years without any immigration status, and that's just their life. So I wanted to go quickly over the basis of asylum law. And just, I think it's important to understand the history and how we got where we are, and really what the kind of foundation of our modern asylum law was a reaction to World War II and the 1951 Refugee Convention. It was really the first definition of who is a refugee, what states, what obligations states have to refugees, you know, what we're supposed to do, how we're supposed to treat these people. And it was passed in a UN conference in 1951. And so then I don't think, you know, I think a bunch of countries signed on to the 1951 convention. Unfortunately, the United States has not, but the United States did sign on to the 1967 protocol relating to the status of refugees, which clarified some things that were not clear in the 1951 convention. And so there's some interesting history there that if you're interested in reading about, I recommend looking into it. And so after the convention, basically different countries had to decide whether they wanted to accede to the convention and then ratify it through their own governmental process. And what the United States did is they acceded to the 1967 protocol on November 1st, 1968, but they're not a signatory. We are not a signatory of the 1951 convention. So we did go through a process of making refugee law a part of our own law, which is great because it's not just this international amorphous law that's out there. We actually have it to use as part of our law, and that was passed as the Refugee Act of 1980. And what we see with the Refugee Act of 1980, where it was the first definition of a refugee in INA 101A 42, for asylum, permanent what procedures we have for bringing refugees into the United States. And the definition of refugee in INA is important. It includes any person who is outside of any country of their nationality. So you can't be, most people cannot be in their own country of nationality and apply for asylum. They have to be in a third country. And they have to be able or are willing to return to their country or to the protection of their country because they were persecuted or they have a well-founded fear of persecution on account of their race, religion, nationality, membership in a particular social group, or political opinion. So really that phrase is very important. That's something that we will be coming back to because, you know, our whole jurisprudence is based on how the courts have been interpreting this statute. And then I put in here the second part, which just provides a little bit more information about the president actually determines refugee. He has a lot of power. He could say that, you know, a particular ethnicity from a certain country, that all those people are refugees, and he could have power to then say, let's bring this whole group of people to the United States if they want that. And so, you know, it's been used through the refugee program a little bit in the past, and I don't think it may be still being used a little bit for Iraqis, but really it's that power is not a focus of the president, the current president. So this is just breaking it down a little bit, understanding what is a refugee. You either have to have been persecuted in the past or have a well-founded fear of persecution in the future. And that persecution in the past or in the future has to be on account of one of your characteristic about yourself. So your race, your religion, your nationality, your membership in a particular social group, or your political opinion. These are known as the protected grounds. I think we've heard a lot about how people just come here for economic reasons or they're fleeing general violence. Those types of people would not be technically refugees because they're not making a claim that fits this definition. So a lot of what we do is we take someone's explanation for why they have left their country and help them fit it into this definition. So what is persecution? Persecution, it's not defined in the Immigration and Nationality Act, so, and it's also not defined in the regulations. So what we've seen are a lot of court cases defining persecution. This case in 2004 from the Ninth Circuit said that it is persecution is an extreme concept marked by the infliction of suffering or harm. So basically there's some type of harm that's been inflicted upon a person that is offensive, which is still a little bit amorphous, but really what we see are the courts then kind of drilling down and giving specific examples of what types of things can be persecution. So specifically, courts say that you have to look at the cumulative effect of the harm. it's not enough just to look at one thing that happened. You have to consider everything that happened. And so that's why it's important to document as many things as you can about the harm a person has suffered, even if, it seems like it was a long time ago. For most of my cases, I start with their childhood. I talk to them about things that happened in the past, even when they were little, because those things that happened to them in the past, affect them today still. And those things that happened in the past should be considered under this effective harm definition of persecution. Of torture, if someone's been tortured, that's, I would say, the clearest definition of persecution. Physical violence, someone's been physically harmed, physical violence coupled with threats or emotional abuse, that has been found to be persecution. Sexual violence is persecution. If someone's detained unlawfully and they're harmed while they're detained, it's also persecution. And I would say if there's psychological, mental, and emotional harm that's pretty severe, you can make a good argument that that's persecution. I mean, I would definitely argue it no matter what. Really want to find everything that happened and argue that it's persecution. So, there is one case that there are a couple cases that say what is not persecution, and mere discrimination is not persecution. I don't know if that overly minimizes the impact of discrimination, but you really, I would say that if you have someone who you maybe was told they couldn't get a job because of their race one time, maybe that's not enough. But that's why you really need to get into the nitty-gritty with clients and figure out what happened to them. So then, what is the source of the persecution is also important. You have, in order to qualify for asylum, the source has to be the government, a quasi-official group, or persons or groups that the government is unable or unwilling to control. This is a hot topic because, and I will get to this later, but Jeff Sessions basically addressed in his recent decision that people who are victims of private violence may not qualify for asylum most of the time. And so really what he's getting at is this idea that people who are victims of groups or persons that the government is unwilling or unable to control may not qualify for asylum, which is not what our law says. We have a really good Ninth Circuit case law that actually talks about this, and so there will definitely be some pushback on what it means that the government is unwilling or unable to control a private group, a private person, and we'll be talking about how you document that hopefully at some point. Not today, maybe later. Basically what this comes down to is, for example, a domestic violence case, if my client has reported it to the police, I have her document that she reported it to the police, I get police reports, and then we talk about what the police did. And if the police didn't do anything, and there's kind of country conditions evidence that talks about how the police don't really do anything for domestic violence victims, then I think that's a pretty good argument that the government is unwilling or unable to control even that specific person. And then I think there are arguments being made that drug cartels, MS-13, some of these really kind of big prolific gangs are quasi-governmental because they've infiltrated the government. Okay, so if you have shown that your client has experienced persecution in the past, so they come to you, they say this and this happened to me in my country, and you think, oh yeah, that's definitely persecution. So basically, once you make your argument, they've experienced past persecution, then you argue based on the law that it creates a presumption of future persecution. All right, this is really key, because if you have a presumption of future persecution, you've already made up a lot of your case. So, and really it becomes a burden shifting exercise at that point. So once you've shown past persecution, then the burden is on the government to show that there has been a fundamental change in circumstances such that the applicant no longer has a well-founded fear of persecution, or that the applicant could avoid future persecution by relocating to another part of the applicant's country. So at that point, it's one of the few areas where the government actually has a burden of showing something. So you really want to hold the government to that burden and make sure that the immigration judge does not just let the government get away with presenting one piece of evidence and saying, we met our burden and rebutted the presumption of past persecution. So it's definitely important to point that out in every brief. Okay, and separately, you don't even need past persecution to qualify for asylum. You can also show that you qualify for asylum solely based on your future fear of persecution. So for some reason, the government rebuts your well-founded fear of persecution, then you can just also show based on future fear of persecution. Okay, it looks like I got a little bit ahead of myself. This is just a little bit more information on the government's burden to establish past persecution. Okay, so if you have a client who, where they had really bad past persecution and for some reason, like things have changed a lot in their country, or their persecutor passed away or something happened so that they don't have that same fear of future persecution, there is a part of the law, it's actually in the regulations listed below, that basically says that the BIA or IJ, immigration judge, may grant asylum to someone who's been a victim of past persecution, even where the government has rebutted it, if the asylum seeker establishes compelling reasons for being unwilling or unable to return to their country because of the severity of the past persecution, or if they have a reasonable possibility of suffering other serious harm upon removal to that country. So, I'd say like this has come up where my client was a victim of pretty severe domestic violence, and she said, well, her abuser passed away. And so, or that abuser may not be looking for her anymore. So she doesn't have the same fear. So I definitely argue humanitarian asylum for those types of cases where the future persecution may not be as strong, but there really is strong past persecution. Okay. So we've talked about past persecution. Now we're talking about a well-founded fear of future persecution. It's enough, like I said, for an applicant to just have a future fear of persecution. You can get asylum on that by itself, okay? I usually don't just go on that, but it is enough, technically. So an applicant has a well-founded fear of persecution if, if they are afraid of what will happen to them on account of their race, religion, nationality, membership in a particular social group, or there's a reasonable possibility of suffering such persecution if they return, and he or she is unable or unwilling to return to that country. Okay, so it's similar. It's pretty similar to the refugee definition, but we're talking about what will happen to them in the future. So one of the things that's important to know about fear of future persecution is that there is a subjective prong and an objective prong. So the subjective prong is based on the applicant's credible testimony. Okay, so basically you need your client to say, this is what I'm afraid of happening, right? Because they don't know what's going to happen. We don't know what's going to happen in the future, but the client needs to say credibly, okay, this is what I believe what will happen. And then we need to show objectively what could happen if they return. So we can show what will happen by evidence of past persecution that gives an implication that such thing could be repeated in the future, or let's see, any type of documentary evidence. Usually this comes down to country conditions evidence or a good expert testimony about the conditions in that country and really whether the person could be subject to the harm that they're talking about if they return to their country. Okay, so like I said, it doesn't require fortune telling. You know, they're not really expecting people to know what's going to happen to them, and we have a couple good cases that say it doesn't require a certainty. It doesn't require even a probability of persecution, and even a 10% chance is enough for you to get asylum. Okay, so this is another thing I often do. I remind, we remind, oh, this is actually a really low burden that asylees have to meet to show future persecution. Okay, and how to demonstrate your well-founded fear. You need to show that you were targeted for persecution in the past, acts of violence against family members. If there's a pattern or practice of persecution against people in your similar situation, that's a way to show it. If you're a member of a disfavored group, one example that comes to my mind is, I've had a couple of clients who've gotten asylum from Iraq who are Sunni, and I said, it's enough that they're actually members of, that they're Sunni in Iraq because it's a disfavored group at that time in Iraq. And then also countrywide persecution, that, that people like this, your client, are being persecuted all around the country. Okay, so now we get to the really interesting thing about asylum law. The persecution that we need to show, not just persecution, but we need to show persecution on account of a protected ground. Okay, so before 2005, the standard was a little bit looser. We just need to just show that the persecutor or whoever did it on account of one of the 5 protected grounds. So in 2005, the Real ID Act was passed, which created a new nexus standard. And that requires that an applicant establish that the persecution on account of the protected ground will be at least one central reason for persecuting the applicant. So it can't be that, and I think this mostly comes up with like extortion cases where it's like, the persecutor wants your money, right? And so they're going to harm you because you're not paying them back. And so really the challenge is to show that it's not just about the money, it's really this other characteristic about the person that was the one central reason that the person was persecuted, or that the persecutor went after that person. And so this is, it is definitely a stricter standard. There was a case in 2017, early 2017, that clarified that this only applies for asylum. It doesn't apply for withholding of removal, which we might talk about later. But it is the standard for asylum. So we need to show, it's very important to show this. Okay, so proving the nexus. It can be really hard because people may not know why they were persecuted. They may not know why they became a target. They really, they don't know. And so you kind of have to think about, help them get into the mind of the persecutors and say, well, why did this person do this? What did they say? What did they say when they were doing it? To try to get any type of information you can about why the person was persecuted. And I think this is an area where a lot of people lose their cases because the immigration judge just may not agree that they were persecuted on account of a protected ground, that was the reason they were persecuted. So you can prove the nexus by showing direct and circumstantial evidence. So direct evidence are statements made by the persecutor to the victim. So if the victim was threatened by the persecutor, please have them write down what the persecutor said, because that is evidence of the nexus. Circumstantial evidence can include I don't know. I mean, I think you can get other types of evidence, like country conditions evidence, showing that people like this person. I mean, one example that comes to my mind are like if the cartels in Mexico persecuted your client, to get whatever evidence you can to show that why they attack people, why they go after people, why they do what they do to different people. And that you should remember that a persecutor can have multiple reasons for harming somebody, as long as a motive on the protected ground is one central reason. So if money is a motivating factor, we will make sure that it is not the only one central reason for the persecution. Okay, so now we're going to get into the specific protected grounds. And the first one I'm going to start with is race and nationality. Race is, I would say, pretty straightforward, right? Usually your clients will know, yeah, this is what happened to me. Like this person attacked me because of my race. And the case law in those cases are pretty clear. The one thing to remember about this ground is that race and nationality often overlap. And so in particular for indigenous people from Mexico, Guatemala, El Salvador, Honduras, you want to ask about whether something happened to them because of their nationality, or because they're indigenous, or because of their race. You really want to try to get that information out, because often if someone is from an indigenous background, they may not think about it as persecution. They just think about it as their life. And so you need to really talk to them about what happened to them, specific events that happened to them. Were they not able to go to a good school because they're indigenous? Were they because they weren't able to speak the religion or speak the Spanish like everybody else? Was it a problem? Did they have problems because of that? So really getting into the details about those things is important. And the next ground is religion. So persecution on the basis of religion can include prohibiting someone being a member in a religious community, prohibiting someone from worshiping in private, prohibiting someone from teaching religion, discriminating against religious people, or harming someone because of their religion. Let's see if I have something next. I have some clients who converted from one religion to another, and then they were worried about what would happen to them because they converted. So it is always important to ask people about their religion and how that informed their lives, how it informed how they live their lives. Religion is one that I often come back to with my Central American cases, because for the reasons I'll talk about after this, because a lot of my clients say, well, I didn't want to get involved in gangs because I was taught that I shouldn't do that. My church teachings taught me that I shouldn't live that type of life. And so I really try to also get information about religious beliefs to show how it has impacted how they live their lives, and how that may have changed how they're presented to or how they present themselves to other people. So this isn't as straightforward as, oh, it was a priest and, you know, they were told by the government that they can't, you know, preach here. You know, it can be more nuanced than that, and I encourage you to look into those things with clients, especially if the claim is not super clear from the beginning. So, okay. So the next one is the membership in a particular social group. This is by far the most ambiguous protected ground. It is frankly a mess of jurisprudence. It's been very unclear for a long time. Cases going back and forth, you know, different circuits saying different things about what it means. So this is really complicated, and it probably requires the most work if you're going to use this as a protected ground. And I almost always do argue that my client is a member in a particular social group, but you really need to think about it and think about how you frame it. And I often argue multiple particular social groups for my clients, because I think some may work, some may not, and I really want to argue everything that I can, especially because of, I think Jeff Sessions is going towards really trying to limit removal hearings, and so we really need to present all the arguments we can up front. And actually there's a BIA case that says if you don't say a particular social group in your hearing, then that's it. You know, you've missed your chance. So I tend to err towards arguing more rather than less, and hoping that the judge agrees with me with at least one of them. So I actually really like Matter of Acosta. I go back to Matter of Acosta a lot for, you know, when I think about particular social group, because really what it says is that, and actually is a really nice, I think it's a pretty nice and clear definition. But it's the thing that I focus on is that it's a group of persons, all of whom share a common immutable characteristic. And then it gives you some examples of innate characteristics, such as sex, color, kinship ties, or in some circumstances, it might be shared past experiences, such as former military leadership or land ownership. And so thinking about, okay, what is an innate characteristic? What are these shared characteristics? What does it mean? How can my client fit into, what innate characteristics does my client have? What are shared characteristics does my client have? And also the shared past experience stuff, I think is great. There are cases that say after that, you know, kind of get around this, but I really like going back to this shared past experience definition in Acosta. Okay, so the courts have found the following to be recognized particular social groups: members of families and clans, gender-specific harm like female genital mutilation. So I think the exact particular social group is a female member of a specific clan who opposed female genital mutilation, or who experienced female genital mutilation. Sexual orientation has been recognized. Former occupations, I think, you know, former policemen have definitely been recognized as a particular social group, but you have to be careful because former professions do not, because they say that you can change your profession. So really you need to, if you're looking at, you know, the former profession or the former thing that your client did, you need to argue why that is an innate past experience. And then we have a couple things that are not particular social groups. Mexicans who were deported from the United States because they say it's too broad, young men targeted for gang recruitment who refused to join. Really, there's just a lot of going back and forth about what's too broad, what's, is this innate? It's very, very confusing. So if you're gonna argue this, make sure you read the cases, which I'm going to list in the next slide. So the most recent case on particular social groups was matter of AB, and what that case did and what we were all fearing Jeff Sessions would do when he became Attorney General was he overruled another case called matter of ARCG. A matter of ARCG basically said that women, I think it was Guatemalan women, I think even maybe it was married Guatemalan women who are unable to leave their relationship is a recognized particular social group. So in overruling matter of ARCG, he basically said, nope, actually not. People who are victims of private violence or domestic violence or gangs almost never qualify for asylum. And so really what our community right now is doing is struggling with this case and addressing it and fighting back against it and, hopefully raising this argument before the circuit courts, because the circuit courts have really deferred to the BIA in the past on domestic violence case law. And so what we're really hoping is that there will be some good circuit court decisions on this issue in the future. And I highly recommend going to CGRS, which is the Center for Gender and Refugee Studies at University of Hastings. They submitted a brief to the Attorney General when he called for briefing on this case. And so you can read some of the arguments that they made in that case, which I'm sure are excellent. And they are really, CGRS is really on the front lines of this. So they are a resource that I'm going to be relying on. A lot of us are going to be relying on in the coming year for sure. Okay, and so then prior to that, we had two kind of big particular social group cases, the matter of MEVG and the matter of WGR. And I think these cases came out like the same day or one right after the other. And basically they were a big deal because they changed one of the prongs of a particular social group. I think before it was there, you had to show that the particular social group was socially visible. And these cases basically said, no, we're going to change this whole social visibility thing. It's not really an ocular thing. It's how the society perceives or sees this social group as distinct from everyone else. So now we have this social distinction prong of particular social groups, and these cases were not overruled by matter of AB. So I think really these are a good place to start if you're making a particular social group claim right now. Okay, and then I wanted to list a couple of recent Ninth Circuit cases. Some of these are before matter of WGR and MEVG. But some of those cases were in response to these cases. So I think it's important. I think it's good to read some of them. I really like the Henriquez Rivas decision. It's an en banc decision. So really, it's a great decision. I really like citing to it. And then there have been some good decisions since then. Reyes v. Lynch is actually the appeal of, I think it's a matter of WGR that was appealed to the Ninth Circuit. And so that case decided on the Ninth Circuit, and I think they upheld the BIA's decision in that case. So that is not a great case, but it's still important for this particular social group analysis. Yes, okay. So I wanted to talk with you a little bit about domestic violence cases. see what time it is. Okay. Domestic violence cases in particular, and gender-based violence cases, because it really has been a long road. We thought we were at the end of it with matter of ARCG, and now we're back where we used to be before it. So matter of RA is, man, that case has a really long and complicated history. I don't even fully understand it, but there was basically a lot of back and forth between the BIA, the immigration court, over what it means to be a victim of domestic violence and how those people qualify for asylum. What particular social group are they members of? So it's good to read those decisions. There's an AG decision, there's a BIA decision. I recommend reading it so you understand the history. And then matter of LR was actually I think it was an unpublished decision. And really what is helpful about this decision is that the Department of Homeland Security at the time, under Obama, wrote a brief arguing why this person qualified for asylum, and included an argument about the member of the particular social group that they belong to. And so that they have a really good particular social group argument there that I'm going to be using, because that was not overruled by matter of AB. So I would definitely recommend checking out that briefing. We also have the Ninth Circuit case Perdomo Beholder, which basically said, I think Guatemalan women could maybe be a particular social group. And it has some really great language about what it means to be like gender plus another type of characteristic that could qualify you for asylum. They remanded that case to the BIA, and we have not heard from it since, so we don't really know what happened with Ms. Perdomo, but I assume she was probably granted asylum, which is why we haven't heard from her since then. There's also Mohammed V. Gonzalez, which is another good I think it's gender-based violence case. So those are good places to start with those. Family is the particular social group. This is still good law. So I argue family is a particular social group for a lot of my cases. In matter of LEA, they were, the BIA, we see the BIA kind of trying to erode it a little bit, but we have in the Ninth Circuit the Flores-Rios v. Lynch decision, which basically said that family is the quintessential particular social group. So if I can make a family-based argument, I definitely make a family-based argument. But we're all on the lookout because AG Sessions basically told us all that he has his eye on family as a particular social group in footnote 8 of matter of AB. So we think that may be where he's going next. And these are some sexual orientation cases. I would say that's pretty well settled law. And gang violence cases. So I would say that this is not a particular social group argument I make most of the time. I really try not to, because there's such bad case law on it. And so I really try to use, I will include it, but I'm not going to rely on it. I recommend maybe shaping it more as a political opinion or as religion protected ground. If someone is opposed to gang violence, I think you could argue that it is a type of political opinion that they stood up to this quasi-governmental group. So, but these are some cases on people who've been victims of gang violence as a particular social group. Okay, and we're almost we are at our last protected ground. Political opinion. To satisfy the requirements of political opinion, you have to show that the person held a political opinion, and that the applicant, the persecutors persecuted him because of his political opinion. So, this could be as straightforward as I was a member of a political party. The government arrested me because of my membership in this political party. So that is can be a very straightforward asylum claim. If you have a client who fits that fact pattern, awesome, that's great. But you then really what you need to do is document the membership in that group. Do they have an ID? Do they have proof that they were in the political party? How were they involved? What did they do? You know, you kind of have to document then their level of involvement in the political party. And then the alternate, so that is what I would say is an expressed political opinion. On the other side, we have someone who can be persecuted because of their imputed political opinion, or a political opinion that was imputed to them. So this can arise even if you do not hold that political opinion. If the government thinks you hold it and they've imputed it to you, and that is why they're persecuting you, then you can be granted asylum based on your imputed political opinion. I think this most of the time comes up with like family members. If one family member was a member of a political party and then the government went after their family members because of that, then that is kind of a classic imputed political opinion case. And I just had one of these granted recently, so yeah, it does happen. Okay, the last thing for this presentation is that you have to remember that asylum is granted as an exercise of discretion. So you not only have to show that they qualify statutorily for asylum, that they meet the definition of a refugee, you also have to show that they're entitled to asylum as a matter of discretion. So basically, you've made your argument, you've done your case, but then your client says, well, actually, you know, I have this pretty serious criminal conviction. And you say, or, you know, something else comes up in their case that really just doesn't sit well, or may not sit well with the judge. You do need to make a discretion argument that it's not just statutorily, that they also qualify as a matter of discretion. And are you why? You know, if there's no negative factors really, then it should be fine. But it's just something to be aware of, because you know, I would say most people, this doesn't really come up, but you need to know about it, and you need to include it in your brief. Okay, so this was a quick overview of asylum law. We didn't talk about a lot of things. I have a separate presentation on how, you know, the mechanics of being in court and what you have to prepare and different types of evidence you need, and how you gather that evidence. But it is 1:55. So these are a couple other topics we could talk about in the future. If you wanted to, the one-year deadline is probably not going to come up with the cases people are working on. Credibility issues are very important, because that is one area where the government thinks it's just very easy to undermine a case. And frivolous asylum claims are basically if people have made up their case. So that's why you need to tell your client, don't make up anything, please, because it really has awful consequences for the client. And it's just, you know, just you have to give them that warning. Do not make anything up if something's made up. Obviously, we have a duty as an attorneys to either withdraw or you know, do what we need to do to make sure we have candor to the tribunal. So I think I'll wrap it up and open up for questions.
Well, thank you so much, Kelsey. This is Takao jumping in. Does anybody have any questions right now? I think probably, I know that was a lot of information, and we did include Kelsey's second PowerPoint in the email I sent to everyone, so should have that to be able to start the review process. If everybody thought this was helpful, we may try and arrange another one of these in the future, so that we have at least a recording of the second part of the presentation as well. But any questions that anybody has? Doesn't sound like it.
I answered all your questions.
Very thorough. With that, I want to thank everybody for joining us so much today. I hope this was helpful for you. It was certainly helpful for me. I definitely learned a lot as an attorney without any immigration specialization. And I'm really, really excited and looking forward to working with all of you on WIDEN and moving forward with these projects, and hopefully really starting to help people right away. So if you have any structural questions, you can reach out to me or Tamina or Jay. If you have any substantive questions, Kelsey was, of course, on the first email, and I'm sure she would be happy to answer any emailed questions as well.
And I just want to point out the last slide, which I didn't get to, just some important resources for you. The Ninth Circuit Immigration Outline is amazing. It really is such an incredible resource. We're so lucky we have it, and that it's updated regularly by Ninth Circuit clerks. So I definitely recommend looking at that. They provide some of the most important cases. And then the AILA Asylum Primer is great. It's $100. I mean, it's a great resource. Deborah Anker's treatise on law of the asylum is also great. I recommend everybody to look at the resources that are available online and in book form. There are a lot out there. It actually makes it so great. Because there really are a lot of resources. So, try to find some things that you online, and if you really are having a hard time getting answers to things, we have a great community of immigration attorneys here, and hopefully the attorney you're working with, they should be very well informed about all this stuff. So, yeah, there's so much to learn.